And then it was Jose's turn to talk. And the first words out of his mouth, and I quote, "I told you from the start I was innocent." Are you kidding me? You told us from the start you were innocent. He told us from the start you're innocent, knowing what we know. So you admitted to strangling my sister until she passed out, quote unquote. You left her there naked with semen on her for hours and hours. And you got garbage bags and you were planning on getting rid of her body, the text messages, but your boys wouldn't help you. So that plan fell through. And the first words out of your mouth in front of her family after everything you did all those things, are, "I told you from the start I was innocent."
And we are about to watch a parole hearing that will just blow your mind. This man who pled guilty to strangulation of the first degree was given a sweetheart plea deal of 10 years. But it wasn't really 10 years, BC, because they suspended all but 7 of them. And parole eligibility after serving 50%. Now, for some reason, the agenda-driven, pathetic, lazy district attorney and judge, they felt that they couldn't convict this man with the jury, even though his girlfriend was found dead in his bed. Even though he was caught on text message asking help to dispose of her body. Even though he was out shopping for garbage bags to dispose of her body. All the acts of an innocent man. But it's the agenda-driven DA and judges that just don't care that much about justice or the victims.
Good morning. First of all, my name is Jose Cruz. My inmate number is 279366.
This hearing is being conducted in consideration for a parole application for Jose Cruz, 279366. He is serving a sentence of 10 years execution suspended after 7 years, followed by 5 years of probation for strangulation first degree. As of today, records reflect a parole eligibility date of September 20th, 2025. There is victim input in this case. There is an offender accountability plan for the offender. It has been reviewed and showed the offender has completed Tier 2 domestic violence and abusive fatherhood. Utilizing the statewide collaborative offender risk evaluation system scores, the offender's overall score for recidivism falls in the moderate range. This is your opportunity to express to the board why you should be granted parole. You may begin.
Go ahead, sir. Why should we give you parole?
So I changed my life to be there for my family. I rehabilitated myself, to do the right thing for the community, for myself, for my family. Shoot, I'm a little nervous. It's the first time I've ever been in the board.
All right.
And
well, we have questions for you. When we're done with our questions, we're going to ask the Office of Victim Services to provide some input. Then we'll deliberate and we'll give you our decision here today. Okay? We'll begin with my colleague, Ms. Smith-Palmieri.
Thank you, Madam Chair. So, Mr. Cruz, in reviewing your file and all the materials, your interview with parole and the materials associated with that, what I come away with is that you take responsibility for being around the wrong people. Is there more that you take responsibility for?
yes, for my actions,
What were your actions? What is it that you take responsibility for?
take responsibilities for putting myself in the situation that I'm arrested for. And being with being at the wrong place, wrong time with the wrong friends, and these actions or this case that I'm in here for.
So why are you here today? Tell us what happened.
Well, I'm here. I was charged with murder at first, and I proved my innocence that I didn't murder nobody. And that's what they dropped the murder charge and hit me with. Offered me a plea deal in the after docket, which I didn't strangle nobody either because I have evidence to prove that I didn't strangle nobody. But I took responsibility on the plea deal and the after docket because my attorney told me to take it so they could drop the murder, and offered me the tampering with a witness also with the strangulation, and that was the plea deal that I took to, instead of, facing the trial that I was on for murder.
Okay, so let's back up here. So you were originally charged with murder. The victim was
Yes.
found dead in your apartment.
Yes, ma'am.
And my read of the situation is that the victim was found deceased in your apartment, that
Yes, ma'am.
it took all day for the death to be reported. And there is documentation that you were out of your apartment looking for trash bags as a way to dispose of the victim. Is that
No, ma'am.
pretty accurate? No, so you were not looking to buy garbage bags and asking people what to do?
No, that was false statements from police. They made a false statement on them.
Okay. So we have this deceased person in your bed at your apartment. Why did you wait so long? Why didn't you report it? Because you didn't even report it. Why did you not report it immediately?
I did call 911, not immediately because I took my son, I had custody of my son, and I took him out the house because I didn't want him to see that, so I could call the police after. So, I panicked, seeing somebody deceased. It's not every day you see somebody deceased, and I took my son out of there to bring him to my sister's house, and I called my attorney, I called my mom to advise of what to do, right. So they told me to call police. So it took me a few hours, but I did call 911 to the police. And then after that, I went to go buy ham and cheese and trash bags, which I didn't have enough for the ham and cheese. So I bought trash bags because I needed trash bags for my house, because my son told me they didn't have no trash bag. It wasn't to get rid of anybody, because I never had intention of doing stuff like that.
Okay, well, let me ask you, do you hear yourself? You have a person that's deceased in your apartment. If I want to say, if as a parent you want to take your child out of the apartment, I can almost go there. But then you want to buy trash bags because you're out of trash bags. And are you the one that called 911? I thought somebody else called 911 to report the death.
When I did call 911, my neighbor from the first floor called 911 first, and I didn't know that until I called 911. The dispatcher told me that, because I have called him before, but he was at work for some advice, and he was at work, so I didn't even really get to talk to him until he called me back. When he called me back, I already had called 911 when he called me back to tell me, I called 911. The dispatcher told me all that too, so. And, the detectives told me they'll call me later on to talk to me. The dispatcher told me, I gave her my number, and they called me at 8 o'clock at night to come get questioned.
Okay, yeah, I guess, we did read what you were originally charged with, that what you actually pled guilty to is strangulation first. There is the tampering with witness and tampering with physical evidence. You have a suspended sentence for that. You have, I read your explanation of things. It's just, it's very troubling in terms of why you would wait so long to report the death when you claim, it wasn't something that you intentionally did. So, but you took the Tier 2 program, you took a domestic violence program, and you've taken the fatherhood program. Did you find any of those programs beneficial?
Yes, ma'am, I did.
Okay. What do you think is helpful about any of them, or one or two of them?
Well, the fatherhood program, it woke me up in a lot of things to be more of a parent and more responsible with my life with my kids. And I did the domestic violence program too. That woke me up too. I learned a lot of steps in there to follow. Never to get myself in a situation or arguments with people, to learn how to walk away, to learn how to control yourself. You only control yourself, you can't control others, but you control yourself in a positive way to make positive decisions. And I rehabilitated myself over the years, doing a lot of thinking of what I've been through in my life to do what's better for myself, for the community. I apologize to the community, apologize to people, for the victim's family for taking so long.
The victim's family, think about the victim's family for a minute. Think about them and how they feel that you could not bring yourself to report her death. I mean, that she was there all day waiting for someone to be called. I mean, who knows? So, and I'm happy that you gained some insight into parenthood. How about the TARE program? You have some history of drug use. There seemed to be some drug use going on that day. What have you learned about using drugs and how that affects your behavior and your decision making?
Well, to stay clean. And I know that being on drugs don't make you think perfectly either, and I never want to do drugs again. I've been clean. This whole time I've been in jail doing a lot of thinking, and I never want to go back to that situation. Never want to go back to doing drugs. I want to stay clean. I feel better being clean and thinking correctly while I'm been here, and I want to stay like that out there in my life to do the right thing, because I almost died that night too of the drug that the person gave me. Also, that's why I woke up. I was able to wake up the next day, and I thank God for that. But I'm also sorry that the person didn't get to wake up from doing the same drugs I was doing.
All right. You've had some difficulties throughout this incarceration. You have 2 tickets. Both of them are for fighting. One, your most recent is September 2024. Are you figuring out how to manage yourself in the facility now?
Yeah, I tried to walk away from the situation, but the person attacked me, so I had to defend myself. I'm not gonna let somebody hurt me. I can always walk away from situation, but if somebody's attacking me, I have to defend myself. And that's what I did in those 2 situations. But I tried to walk away, and I tried to tell them I don't want no problems, and I try to do the best to walk away, but they try to attack me, so I had to defend myself.
Well, the last altercation, you said that somebody was trying to take your tray and you didn't want them to take your tray. So they weren't attacking you. Why not just let them take your tray and report it?
Because he did attack me, because I didn't want to give him my tray. And I put it down and I told him to get away, and I started walking to my cell. He followed me over there and swung at me, first punched me in the head. So I had to defend myself.
And then you have a release plan to go to live with your mother, and she has agreed to sponsor you?
Yes, ma'am.
Okay. How about employment? Given any thoughts to that? What you'll do?
Well, I worked a lot of jobs. I have a lot of experience in different fields. And, I can find a job easy. That's not hard to do. Okay. If I go live with her, she said she'll give me a job as PCA to take care of her. So I will have a job right away, if I do go live with her.
All right, Mr. Cruz, thank you. I have nothing further.
Thank you very much.
Thank you.
Mr. Cruz, do you know why you were convicted of strangulation first?
Yeah, they tried to say I strangled somebody. I strangled a person and they died, which that wasn't true.
Well,
That's
do you
why
know
I
what
took
the
it
medical examiner's report said? Do you know what the evidence was?
Well, the first one, when I got arrested for the warrant, it said undetermined. There was no signs of marks of strangulation or none of that. And then after my probable cause hearing, that I was able to bring an examiner of my peer, and he said there was nothing but a drug overload. There was no marks, no strangulation, no nothing either. But after that probable cause hearing, their examiner changed to homicide after the probable cause hearing. When I was in jail, undetermined, it was never ruled a homicide. The whole time I was in jail until after the probable cause hearing, based on the statement from my ex-girlfriend that I didn't want to be with her, so we made up a false statement with the police to arrest me for murder that I didn't do. And it was all based on a false statement.
Okay, is that the same witness that you had contacted from prison?
Yeah, my ex-girlfriend, which I didn't contact her. They sent a guy that I knew that came to me to try to communicate with me, that she wanted to communicate with me. I told him, I don't want nothing to do with you or her. You know, in the recording, I didn't know that he had her on the line, on the phone, on the tablet.
You know, we read the transcripts of that phone call, so we're very well aware of exactly what was said.
Well, I didn't know that she was on the line.
Well, who did you think he was talking to on the phone?
Nobody. He didn't have it on. That was on the table. His tablet was on the table. He didn't
was
have it on.
going back and forth making statements between the two of you.
No, that was when I listened to the phone call myself.
Mm-hmm.
I listened to the phone call myself, and it doesn't say nothing about me trying to reach out to her or me offering her money to recant her statement. I never said none of that. That's why it was based on the warrant that they arrested me.
Did you have a domestic with her?
No, I never had domestic with her. That was all false statement. That's when they threw that out, because that was false. I never had no 911 call and never knew domestic with my ex-girl.
Did you ever assault her?
No.
Okay. Mr. Zarko. All right, give us a few minutes to discuss your case, sir. Oh, no, actually, we're going to ask the Office of Victim Services to provide input now, and we'll ask you, please not interrupt, but you can listen. Ms. Hamlet-Williams, thank you.
Thank you, Madam Chair. I do have several family members who would like to address the board today. First, I will read a statement from the aunt of the victim, aunt/godmother, who also was allowed to speak at court. I will read that statement first, and then I will give a call for the family members to participate via speakerphone. One moment.
Thank you.
To whom it may concern. Good day. I'm writing on behalf of our family. I am Lisa Maria Chinova's aunt and godmother, and I spoke in court in regard to this case. I'm asking you to please consider our family's great loss and the hardship we faced since June 22nd, 2017, when an officer knocked on our door. I'm also a pastor who believes in forgiveness. However, in court for the sentencing, I've witnessed from the defendant no remorse, a smirk on his face, no rehabilitation, because he stated, quote, that he's still innocent, end quote. And the judge had to correct him in court saying, quote, why did you take a plea bargain then? You're insulting the family of the victim, end quote. It troubles me to know that the board is willing to release this man and possibly put other young women's lives in danger, considering he has a history of abusing and assaulting women. Our Lisa was so full of life. We will never get to see her at our Sunday dinners, never get to give her another hug, never get to see her future, never know if she would have had children. The defendant gets to go home to his family after messing ours up, and it's not fair. That my niece's life was cut so short because of strangulation, cruelty, hatred, selfishness, and no self-control. It saddens me that a precious life equals 10 years, and even now, the defendant believes he deserves an early release. I hope and pray you will consider your decision of not releasing the defendant early and let him truly pay for his behavior of strangulation, which I believe led to our Lisa Marie Chinova's death and being robbed of her life prematurely. May God bless you all. Very truly yours.
Thank you. And we did get that email earlier. Thank you.
Okay, and I will now send the next call to the brother of the victim. One moment. Thank you. You may begin with your statement.
Hi, how are you doing today? My name is Sean Chinova. I'm the brother of the victim, Lisa Marie Chinova. Obviously, today is about the possibility of Jose getting out even earlier than expected. I think it's like a month or whatever it is. I'm not sure if you guys have been at any of the court hearings or anything like that, so you didn't see anything leading up until today. I wasn't able to listen on to what was said. I know you guys had to ask him questions and stuff like that first, so I wasn't able to hear any bull crap that came out of his mouth today. So I can't speak on what he said today, but I could speak on what I've seen since the first court date to the last court date, which, in case you guys are not aware of, I will enlighten you. So obviously for rehabilitation, you need to show, that you've had good behavior in prison, no fights, which I'm, not surprised at all. I don't think anybody is, because Jose is in prison with a bunch of men. He doesn't have history of violence against men. He knows better than that. He is the kind of person who has a history, and I just want to make sure the word history is very clear, of violence against women. But this wasn't his first unthinkable, unspeakable, terrible thing that he did to my sister. He did to another girl, the witness that he tried to bribe. She thought she was going to die. Those are her words. She thought she was going to die. Her life was threatened. She thought she was going to die when he was strangling her too. So I just want that fresh in everybody's minds, no matter what. So what he said today is just abolished. So he has that part of the rehabilitation covered, because, like I said, he's in prison with men. He's not going to get into fights with men. So, okay, he has that on the side. But the other thing you need to show some type of remorse, right? Or accountability. And he did nothing of the sort from the first case for the first court date to the last. If anything, and you can ask the judge if you need to talk to him afterwards, he was cocky, arrogant, and disrespectful, if anything. In fact, in the last court date, the judge had to say to him, hey, if I hear anything out of your mouth, you said guilty or not guilty or whatever it was, then we're going to throw away this plea deal, and that's it. Because he was disrespectful, he was arrogant the entire time. He showed no remorse, no accountability. And you need to show that if you are a rehabilitated person. And on the last court date, just to top it all off, when we talk about accountability or remorse, my whole family that was able to make it got up, we said our piece. There's nothing we can do about the case anymore. And then it was Jose's turn to talk. And the first words out of his mouth, and I quote, "I told you from the start I was innocent." Are you kidding me? You told us from the start you were innocent. He told us from the start you're innocent, knowing what we know. So you admitted to strangling my sister until she passed out, quote unquote. You left her there naked with semen on her for hours and hours. And you got garbage bags, and you were planning on getting rid of her body, text messages, but your boys wouldn't help you. So that plan fell through. And the first words out of your mouth in front of her family after everything you did all those things, are, I told you from the start I was innocent? Does that sound like somebody to you, board members, who is rehabilitated? Because sure as hell does not to me. This guy has no remorse. No matter what he said today, he's trying to get out in a month for what he did. No accountability. I just want to end with, today is Jose's big day. He is filled with all this hope right now that he gets to get out in a month and be with his boys again, gets to be with his family. He has all this hope today. And I'm just asking you, our family has been through hell because of him. And we've lost every court case or court date, the way this all ended, it feels like we just lost and we're losing so much more. I'm just asking for the tiniest bit of a win, if you want to call it that, to just take his hope that he has today and just destroy his hope of getting out early. And just, I want today to end in, you know what, Jose, you're not getting out an hour, a day, a second earlier than next year. Because you know what, right now, it feels kind of close to him. He has this hope right now. So at least if you take that hope away from him, and maybe he leaves today just even sad just a little bit, take that hope away from him today and give the Chinova family a little bit of a win, and just let him know that what he did is not excusable, and he's not going to be rewarded with any getting out early, free card. Not a review in 6 months, just no. Jose, you're not getting out a day earlier, a second earlier. And I'm just hoping that's what the conclusion comes to today. So at least, like I said, we can walk away. Maybe we feel like we took a little bit of something from him, and that was just a year. But he took away my sister's entire life from her. Okay? We don't get to see her ever again. I'm just asking for one more year and not to give him this reward. That's all I'm asking for. Because just like he has hope today that he might get out in a month, I guarantee you, my sister Lisa, she had hope when he was on top of her strangling her that he would let go and she would make it through that night. And he did not let go. So he does not deserve this. And I'm just begging you to not give him this and just take away this hope that he has today to make it feel like a little bit of a win for the Chinova family and for my sister. The tiniest bit of justice is all I'm asking for.
Thank you.
Thank you.
Thank you so much for your statement.
All right. Have a good day.
You as well. Next, we'll hear from the mother of the victim as well as the sister of the victim. One moment. Thank you. You may begin with your statement.
Hello, good morning. I would just like to address the board for a moment. After hearing what Mr. Cruz has said this morning, I can't say that I'm surprised. He's definitely kept it consistent. He is still not taking accountability for murdering my daughter. He's still saying he didn't do anything wrong, and it seems that I'm hearing him say it's everyone else's fault around him but him. So my daughter gave him the drugs in his statement today, and I guess she must have forced them down his throat, and then she must have put his hands around her neck and squeezed them for him because he didn't do anything wrong. This whole time, from the very first case court date I went to for him until now, there is no accountability whatsoever that I am hearing or seeing. He's even going as far as to say the police, it's their fault. They're lying about him. The statements the police made are false. He didn't call his neighbor and ask to dispose of my daughter's body. He didn't go to buy trash bags, which was even in the newspaper, and he said that it was just too much money. So my daughter wasn't even worth the money for the trash bags for him to dispose of her. So this man, all I'm hearing from him is nothing is his fault. So if he's not taking zero responsibility for my daughter's death, if he's taking zero responsibility for any of his actions that led to her death, or any of the statements that he made, including threatening Delilah, trying to bribe Delilah, which was the witness, his ex, all of this, it's all lies. That's what I'm hearing. It's all lies. It's a conspiracy against Mr. Cruz, and nothing that happened is his fault. He's just a victim himself in all of this, and that's why he's sitting in jail. It disgusts me, and I certainly hope that the board can see through this as well, because I'm sure you're all very intelligent people. This man has no accountability, no responsibility for the fact that my daughter was murdered by him in his apartment, left to rot all day. And I really hope that the board sees what I see and hears what I hear and does not give him early release, because he definitely is a threat to the community, and all the pain and the loss that I have experienced and each one of my family members have experienced at the loss of Lisa Marie, I don't want another family to go through. And this man is definitely capable of committing these acts again, because he's taking no responsibility for what he has already done. So I don't want another family to go through this and have to come on here and talk to you about early release to a man who has taken their daughter as well. And I just would like to ask you to please consider that today, and do not give him early release, please. Thank you.
Thank you.
Hello.
Hi.
Yes, we can. You may begin with your statement.
Okay. Hi. I'm Lisa's sister. I'm Carrie. I just want to say I don't really know how to start, but I just want to mention the way that we see my sister in her casket at the wake. That's where I want to begin. We had to see her with bruises on her, lumps on her forehead. That was never brought to the police or anything like that, or never brought to court. I'm sorry, never brought into court. We didn't have a chance to go to a jury. We had to see her fingernails, all of them, every single fingernail ripped halfway down the nail bed, in which he said was rough sex. And I'm sure we can all agree, I don't see how that can happen with all your nails ripped down halfway down your bed. So we had to see all this, okay? Also, what I want to mention is from the court, like everyone else is saying, he has no remorse at all. Everything, the ham and cheese thing, I'm stuck on. I don't, I'm sorry. But what I want to say today is going through everything we went through, from seeing her, from the knock on the door to the casket to the court hearings, and nothing really happening, no justice at all. I'm just asking today that the board can see through all this, and just consider not releasing him, because he does not care. He does not. He just wants to get back out and live his life after he took a life. And I'm sorry, 10 years isn't enough for my sister's life. A year, nothing is worth. There's no time. But I just want to say he took a very important person to me. She was my best friend in the world. We did everything together. My kids don't know her, nothing. She never had kids. It's a very emotional time right now. And I don't really know what to say at all. But regarding his last statement at court, which I heard that a few people have mentioned, but that I've been innocent this whole time, I can agree. It does not sound like a rehabilitated person at all. Not at all. I think that if he had any remorse or any sign of rehabilitation in the sentencing that day, he would have said something like to the victim's family, "Hey, I'm so sorry for your loss, but or just something to show that you were sorry, even if you didn't do it, according to him. Just show some kind of remorse, show some kind of respect to the family, instead of trying to just save your own behind, But I just hope you take everything we all said today in consideration. I don't believe he deserves to get out at all, or ever, but this is what we have here. That's all I got to say.
Thank you.
Mm-hmm.
Thank you so much. Please continue to view. And lastly, I will be calling the father of the victim to address the board. One moment. Thank you. You may begin with your statement.
Okay. Good morning, members of the parole board. My name is Christopher Chinova. I am Lisa Chinova, who was the victim, Lisa Marie Chinova's father. When I was listening to the statements of my son and my daughter and Lisa's mom, Michelle, it went out a couple of times, perhaps because of the cell. So if my phone does do that, even though I'm sitting still, please stop me so I can make sure I correct that, okay?
Yeah.
All right. I listened to everything this morning time. I was glad I got to listen to Mr. Cruz first. I mean, Michelle, who's Lisa's mom, who spoke a few minutes ago, is kind of on the same racetrack as I am, in regards to rehabilitation. Mr. Cruz sounds like a victim. He sounds like all these things happened to him, and he's just some innocent victim who's been in jail for 6 years, and because of someone being with the wrong person, meaning my daughter Lisa Chinova, gave him drugs. And what I did ask the prosecutor, who, by the way, didn't even know my daughter's name. He kept calling Lisa Delilah Reveron and vice versa. So that was how, unfortunately, the case was handled by the Waterbury court, by Attorney Ryan. But Lisa Chinova gave him drugs. And so the strange part about it is that my daughter did have a problem with drugs, and we take accountability for Lisa's actions. And it's funny how a person who had a drug problem, who had a tolerance, didn't survive the drugs that they were both doing, but he somehow did survive it. Not only did he survive it, because according to Mr. Cruz, Lisa didn't wake up, but not only did he survive these drugs that he shared with my daughter, he was able to do all these things. Now, he says that she was there a couple of hours. I heard his statements, and I listened to them pretty intently. And, I was at the probable cause hearing. I was at every single court date that he had. The original prosecutors gave us the story, the written statement in the file. And I don't remember them saying that Mr. Cruz called 911. My understanding was his downstairs neighbor is the one who called 911. And also he had sent a text message to her, either her son or her grandson, to help me get rid of a body. Now, the man refused, and then told them someone's dead upstairs, and they're the ones who went upstairs and called 911. And also, according to a statement that I received from the prosecutors, that my daughter was in that apartment dead for 12 to 14 hours. I don't know what things Mr. Cruz had to do during that time to leave her up there. And again, when I asked about, isn't it the actions, the first judge did mention about his actions are not the actions of an innocent person. That's why the probable cause hearing didn't work out the way Mr. Cruz wanted it to, was because the judge told him your actions are not the actions of an innocent person. But I was also told that disposing of a body is not a crime in Connecticut, which was kind of appalling, but that's just the letter of the law. And I guess this is all about. And I do have a question, if someone can answer this. Today's hearing, is this just a formality because my son, my daughter, we asked this to Ms. Williams, is this just a formality, or has this already been determined? Like in court, we had to speak in the last day of court that my son referred to. And we open up all these wounds that are inside of us. We say all these things, but they already had made up their mind. And that's why I told Ms. Williams, it's kind of not fair that every time this comes up, we have gaping wounds open. We already have them there. They're not going to go away. But we have to open these things up. We have to recant it, think about all these different things. And then after it's over, it might end for you. It might end for Mr. Cruz and everyone else, but it doesn't end for us. It's perpetual. So if someone can answer me, is this just a formality, or, are you guys making a decision after this hearing today, or has the decision already been made?
I can answer that. The decision has not been made yet. The decision will be made at the end of this hearing.
Okay, so possibly what we're saying, there is a chance that Mr. Cruz may not be able. Okay, thank you for that. But Mr. Cruz mentioned during the probable cause hearing about his ex-girlfriend Delilah Reveron making up lies and everything else. But I listened to the whole probable cause hearing, and you guys can find the testimony, which I'm sure that's necessary to do. But he said he wanted nothing to do with her. But Miss Reveron was testifying how he was trying to marry her. This story about a ring and being at the mall, and his attorney at the time was making a case saying that, well, why are you engaging Mr. Cruz, with all these things, him buying you a ring, if he's so horrible, okay? And basically, it wound up turning out Miss Reveron said, well, I agreed to everything he was saying, like the phone calls to the thing. Hey, baby, do you remember that? She was saying I was afraid, and I told him anything he wanted to hear. But if he wanted nothing to do with her, then why was he trying to marry her? I have an idea why he wanted to marry her, because someone probably told him that your wife can't testify against you, which he didn't realize she'd already made a testimony. But yeah, a wife can't testify against her husband. So maybe that's why he was trying to marry her. And now he's telling you guys that he didn't want nothing to do with her. And that's why she made up all these lies. So the original reason why she went to the police, which caused them to finally arrest you, because it took 2 years to arrest Mr. Cruz after Lisa was killed on the 22nd of June in 2017. So it took about 2 years to arrest him. So he's saying that he did not want to be with her, and so she made up all these lies. So what we understood was that he assaulted Miss Reveron, and she went to the police to report the assault, but also said, I have information on what he did to someone else. And that's how the case got going, which led to his arrest. Because if you think logically, it sounds like Mr. Cruz was sitting in his apartment, and the police for 2 years were doctoring up some case, and then finally figured out how to lie about him, and then brought him in. But what precipitated them to bring him in? It was him assaulting Miss Reveron, which he said he's never done before. Now, we did ask the prosecutor, Attorney Ryan, how come these things can't be brought into court? Like, why can't we show his history of his first baby's mother, the assault on her, and the one of Miss Reveron? And they were telling me because it can be prejudicial to this case. Just because he attacked them, it doesn't mean he attacked Lisa. That's what we were told. That's what I was told. So again, Mr. Cruz has my daughter, give him drugs, supposedly, and he wakes up with this, how dare her die in his apartment, and then he had nothing to do with her death, and does all these things, like purchasing garbage bags, which the first judge, he probably doesn't remember, but Solomon said, I don't think you're funny. That was the judge in the probable cause hearing that found him, that the case should go to trial. He didn't find Mr. Cruz funny. And that was the only time Mr. Cruz kind of showed some seriousness in that courtroom, because like Sean and Michelle said, that he was very, very, lackadaisical about it, very disrespectful, always making hand gestures like what, and like all these different things. So all these things happen to this poor guy, and he wakes up with this dead girl next to him, but decides to get rid of her body. If I woke up tomorrow morning with a dead woman next to me, and I decided to text someone and say, which they had to text, but they couldn't get the guy to come in and testify against him. I have a dead woman here. I want to get rid of her body. I know I'm in trouble for just doing that, even though it has nothing to do with her death. But then leave her there for 12 to 14 hours. I'm not the reason why the police found her. Someone else called, and the police are there. My understanding was he wasn't even home when the police got there. So like, he's telling you all these things, but I hope you have a background in the file what happened, because the attorney that we had, Attorney Ryan, really just seemed like he didn't care. And like, I don't even know if he even read the file. I still haven't heard Mr. Cruz say my daughter's name. She has a name. It's Lisa Marie Chinova. He keeps calling her the victim, this person. I guess if I asked you that question about if your mind was made up, was because, maybe I can't change people's minds. And I finding out in life that you can't change people's minds. But maybe if I can get you to feel a certain way, to feel like I'm feeling. And if any of you have children, okay, let's just say that you tell your child to go out in the wintertime, but make sure you wear a coat, okay? And the child doesn't go out and wear the coat because they don't believe they're going to get sick. And then your child catches a cold, and the cold turns into pneumonia. And you're like, okay, you got to take your antibiotic. And they don't take their antibiotic. And you tell them it's going to get worse if they don't. And the pneumonia gets worse, and it gets in their lungs, and their lungs fill up. And then that child, unfortunately, from not listening to your original instructions or your instructions when they were sick, they die. And then someone turns around and says to you, well, they kind of got what it was kind of their fault anyways. They played a part in their own death. How would you feel about that? Well, that's kind of how our family feels. That Lisa, yes, she did drugs. She was told younger not to do drugs. You know, she tried to get treatment for it, taking her medicine, which she didn't take. And then it seems like the court or maybe the justice system and Mr. Cruz feels like she kind of is responsible for her own death, which she did play a part in. Now, Lisa's not here to account for herself. Lisa's not here to say, well, I took drugs and it did help lead to my death because I was with someone who I should not have been with, who strangled me. Now, he wasn't convicted of murder, so we can't say, according to law, Mr. Cruz murdered her. But he did plead guilty to strangling Lisa. And he's still sitting here in front of you saying, I didn't do anything, but I'm rehabilitated. And basically what our family feels like is like you would feel about your child, unfortunately, who passed away from the pneumonia. Well, it's their fault. Okay, well, again, Lisa played a role, and we are here to account for Lisa. She should not have been doing drugs, no matter what happened to her, whether she was strangled by Mr. Cruz or not. But he did, by his own admission and his plea, say, I plead guilty to strangling Lisa Chinova. I plead guilty to that. I'm pleading guilty. So the rest of my life, no matter what my story is, it's going to follow me around that I strangled Lisa Chinova. They gave him 10 years, okay? And if the court says, hey, you got 10 years for this, and that's all you got to serve, at the end of 10 years, you don't have to be rehabilitated. You served your time. But if you want to get out early because something has changed, you know, you've been rehabilitated, maybe Mr. Cruz's demeanor at court, maybe the time he's been in jail, you know, he's saying he's changed and done different things, and he's done only different programs, and now all of a sudden, well, let me out early because I'm better now. Like you would in someone who's being treated in the hospital for pneumonia that possibly killed, like, you know, if it killed one of your children. You let him out early if the medicines work. Well, his rehabilitation, is his medicine working? Is his medicine working to the point where he's saying, you know what, I can't account for what I did? Not it's, well, I was with the wrong people, you know, the wrong things happened. This girl gave me drugs and I didn't do this, I didn't do that, I didn't do that. Well, everyone in jail didn't do it, Mr. Cruz. The jail is full of them. The jail is full of people who didn't do it. All right. It is a very unique position that you find yourself in, having someone saying, well, I didn't do it. Okay, well, you're saying you didn't murder her, but you are saying that you strangled her. And you want to get out early. I can't talk to him. I'm sorry. He wants to get out early. All right. And because he's been rehabilitated. And again, like Michelle said, doesn't rehabilitation start with some type of accountability? I want to be better because I realized my mistake. But how could you realize your mistake if you say you didn't make a mistake? How can you say I'm better when you didn't do anything? Better from what? Where's his starting point where he's saying, hey, I did I was around the wrong people and now I'm better? But you didn't plead guilty and you're not in jail for being around the wrong people. But by the letter of the law, that's all we're talking about. You pleaded guilty to strangling another human being. And he takes no accountability for that, ma'am. I'm sorry, members of the parole. He takes no accountability for it. You heard him. I can listen to him the whole thing. And I think it's a problem. And I'm not saying he's going to go out and do this again to someone else. I'm not even worried about that because that's not going to bring my daughter back. Nothing's going to bring my daughter back. But a judge did find at one point that there was reasonable cause to believe he had something to do with Lisa's death, whether the strangulation led directly to her death or not. The fact is he pleaded guilty now to strangling her. And he's telling you right to your face that he didn't do anything. How can you call that man rehabilitated for early release based upon, predicated on what he said? I just don't understand it. And I hate to do this at the end, but this is just me. I received a letter yesterday from the Victim Services Unit, and I'll just read the first paragraph. The Department of Correction Victim Services Unit has requested for victim notification that you on file with regard to the above referenced name, and that's Jose Cruz, inmate number 279-366. Pursuant to Connecticut General Statutes 18-81E, we hereby are informing you that the above named inmate has been approved to complete the remaining part of their sentence in a community release setting. That's why I asked the question before this, has this already been decided?
That's a different process. That's the Department of Corrections, sir. They're a different agency. I can't speak for them.
Well, no, I'm saying, but that's why I asked that, if you're wondering why that strange question occurred, because it was upsetting sitting there all night and knowing that my family didn't know this, because it sounded like to me from an area that, from where I was sitting, that this has already been decided. And my family, once again, is going to open up these gaping wounds to a non-prejudicial body. And, the decision's already been made. So it was hard sitting on it last night.
Yeah.
But I'm not going to go on any longer. I went on long enough. I'm sorry.
Thank you.
I was long-winded. There's so much to say because there's so many wounds, but I really hope that you consider not releasing someone who obviously has not been rehabilitated.
Thank you. And thank you to all the family members for your statements. Appreciate it.
Williams. Hey, I hope you all have a nice day.
Thank you. Is that everyone, Ms. Hamlet-Williams?
Yes, thank you so much, Madam Chair. Thank you, Pam.
Okay, thank you. Mr. Cruz, give us a few minutes to deliberate about your case and we'll come back to you shortly with our decision. Ms. Smith, I'm here.
Thank you, Madam Chair. So thank you to all the victims who came forward. We heard the victim's father loud and clear that he does open all these wounds for them. It's a terrible situation. And I have to agree. Mr. Cruz doesn't seem to take responsibility or even acknowledge his role in any of this. The fact that he has this deceased person in his bed and he waits all day, never reaches out. It's hard to understand. It's hard to understand that just to begin with. He does score moderate for risk to recidivate. He's got 2 disciplinary reports, both for fighting. I appreciate that he's taken some good programs. I do hope that they benefit him when he is released. But for today, I do not find him suitable for discretion.
I agree. Mr. Sharkey?
I agree. And I would just add tampering.
Yeah.
It's very concerning. To try to contact the witness, or by the way, there was a protective order in place already. Try to contact the witness to change their previously sworn testimony. It's just a lot to overcome.
Thank you. In the matter of Josue Cruz, inmate number 279-366, I move to deny parole for the following reasons: the nature and circumstance of your offenses, the injury and impact to the victim and the victim's family, and your poor institutional adjustment. Anything further?
No.
Is there a second?
Second.
All in favor? Aye. We wish you the best, sir. Thank you, everyone, for your participation.
I didn't say I didn't take responsibility for my actions.
Okay.
I didn't say I didn't take accountability. I never said that. For you to say,
You don't have to say that outright for us to get that impression, sir, but you've been denied parole. We certainly wish you the best. Take advantage of your probation and keep working on yourself.
I have been, and I'm gonna keep working on myself. You don't stop, any day to keep working on yourself. It's an everyday thing.
Okay. That's it. Thank you.
This is moving out, Jose Cruz 279-366. Thank you. You're all set. Good luck.
It's not fair.
We're going to take a 3-minute recess. We'll be right back.
You know what this hearing proved for me, and maybe for you as well? It brought to the spotlight everything that we've been saying and seeing, but without actually having validation for it. And that is how the prosecution and the judges do not care. We heard in this hearing that even on the day that they handed down the sentence, the prosecutor did not know the victim's name. Now, I know there's politics and complications. The district attorney is calling the shots. You can have detectives that say, hey, we need to arrest this man. Here's the text message proof. He's asking for a body to dispose of the body. There's evidence that he's out there shopping for garbage bags to dispose of her. Yet the district attorney would say to them, no, you can't arrest him. That's not enough evidence to arrest the man for anything? How is that not enough evidence? You don't think a jury could find a man guilty for that? And then they wait 2 years for an ex-girlfriend who gets something similar to her to go to the police. And I believe she told the police that he had confessed to killing this woman. That was enough to then at least bring charges. But still, they didn't feel they had enough to take it to trial. But again, even if you want to make these arguments, even if you want to say that they just felt there was no chance they'd win this case, they had to do a plea deal. There are a few other points that I want to bring out. One is that the offense, which the parole board even brought up, saying that this is such a strong mitigating factor. Mitigating might not be the wrong word, but a strong factor as to why they shouldn't parole was the tampering of a witness. That was a Class C felony. That happened 9/26/2022. That is many years after the offense date or verdict date of the strangulation. But the judge and the DA gave him 5 years suspended sentence. You can't have your cake and eat it too, as much as I hate that analogy. It makes no sense to me. But here they are saying, well, we can't prove that you killed, so we're going to do a plea deal. But then they have him on the tampering of a witness, and they don't make him serve any time for it. It gave him a suspended sentence. That they could have prosecuted to the fullest extent of the law, which in the state of Connecticut is a maximum of 10 years. They could have given him 10 years simply for the tampering of a witness, which would not have been difficult to prove. But not only did they not give him 10 years, they gave him 5 years. And not only was it not 5 years, but they suspended all of it. It means nothing. Then when you come to the strangulation case, this is again more things that we proved. I've always said this, that the sentencing guidelines, we've been saying it as a community, that it's all a gimmick. It's a tool to gaslight the constituency. We just covered a hearing the other day where someone was given a what was it, a 20-year sentence, but it wasn't. It was all suspended, but 7. And here you heard the victims saying over and over, you heard the victims, because they don't understand the plea deal that was given. They kept saying 10 years is not enough. 10 years is not enough. 10 years is not a long enough sentence. I don't think they understand. It's not 10 years on paper. I mean, I guess it is. On paper, you look at it, it says 10 years, but it's suspended after 7. It's only a 7-year sentence. They do this to manipulate, not to manipulate the bad guy, the criminal, the strangler. They do it to manipulate the victims and the public. We heard firsthand the victims, they had no idea that it wasn't really a 10-year sentence. And insult to injury, the DA doesn't even know the victim's name. And I don't buy any of, they just didn't want to take it to trial. What would happen if you take it to trial? You'll at least find him guilty on the tampering with evidence, or you'll at least find him guilty on the separate felony of tampering with the witness, because they're two-faced liars. The DAs do not care about victims. They do not care about releasing dangerous felons back into the street. They are the problem. And we heard firsthand from the family, and I guess we can give Connecticut one benefit over the other states that we cover, is they do give a voice to the victims and they let them talk for as long as they want, and I'll call it out: the good with the good, the bad with the bad. Louisiana would have said, wrap it up after 3 minutes. At least Connecticut does not do that. But can you imagine how insensitive they are, where they actually send a letter saying this person has been found, that they're approved. So everybody, all victims get that letter, and that letter is not clear to anyone who's never been through this before. They don't know that it means they're approved to have a parole hearing where then a decision is made. No, when you get the letter, you think the decision's been made already. That's sick. That's an easy fix, guys. Fix it. It's the craziest thing. You find out about a man who, I mean, who strangled. So they play cute with this plea deal. He pleads guilty to strangulation first degree. She's dead. So what they're trying to tell us, to gaslight us with, is, well, we know that he strangled her, but we don't know that was the cause of death. But she's dead. It's just, and then he texts a buddy and says, let's get rid of the body. And then he goes out looking for garbage bags to dispose of the body. And they don't think they have enough evidence to at least go to trial. And all I got to say is, like, why do you have this job? Why are you a prosecutor? Why did you become an attorney and then say, I'm not only going to be an attorney, but I'm going to be a prosecutor if you can't take this case? And there's a few reasons why I think they're so jaded. They don't even know the victim's name. They're tired. They forgot why they got into it. There's also a lot of other problems. They only care about win percentages. It's come down to stats, and that's why they don't prosecute chomo cases, because chomo cases, they're hard to win. Maybe you'll win 80% of them, but a 20% loss rate is terrible. These DAs, they want to have 100% win rates, because that's a very easy thing to get reelected on. They just say, I have a 100% win rate. But what we need to do, really, and I've been thinking about making a non-for-profit startup. It's been going through my mind. I've talked about it with Sir Richard. With all the craziness that's going on, I don't know, but it would be to collect data on all the DAs and all the judges and make the data very easy to understand. It would be like a baseball card. You would have the picture of the DA, and the back of the card would have their stats. And the stats wouldn't be win-loss percentage. The stats would be, that would be one field, but the stats would be how many cases came to your door, how many plea deals did you give, how many of them were chomo cases, how many of them were probation that you gave. Because that's the only way to paint a picture and to stop this insanity of DAs saying, you know what, there's a 10% chance I'll lose this strangulation. I know that he strangled her. I know that he tried, we have all this evidence, but it's not 100%. So I'm just not going to prosecute it. Instead, what I'll do is I'll give them a 10-year sentence, but it's really just 7 years and parole eligibility halfway through and probation 5. And let's just get it off. I don't think I can win it. Oh yeah, he killed Monica. Oh, her name wasn't Monica. Oh, Rebecca. Oh, not whatever. He killed someone. Who cares? I can't win this case. And they shove it under the door, and there's no. By the way, try finding on the internet anything about the sentencing. You'll find plenty when the crime happened, but not because they don't want it. They don't want press releases. They want this all under the rug. They don't want anybody to know about this. And until we started covering parole hearings, nobody knew about this. The victims' voices were not heard, and now at least they can be. But we need to do more. We need to do more because it's come down to what's in it for the DAs, and the DAs do not care. That's it, summed up in a nutshell. And on that note, I'll play another hearing, a hearing that you will want to rip your hair out. And it's a hearing where, again, the judges and the DAs will let a monster, where they had every bit of evidence, where they did not need to put the victims on the stand, where they were holding the royal flush, but still they did not want to take it to trial because it didn't fit their agenda. And with that, let's jump in.
How you altered them, and you've pretty much photoshopped yourself into the images with these. And the videos were in those bedrooms. Two separate homes were strategically placed so that you could tape minors when they're.
We are about to watch a parole hearing that will make you scream. You see, this man, he was a teacher for freshmen. He was also a coach. He coached basketball, he coached soccer for 2 different school districts. He just couldn't get enough of kids that age. Now, an FBI investigation found a high school ID uploading CT to their servers. That sparked an investigation that lasted 6 months. They went to the school, they raided his home, they took his computers, and what did they discover? Hundreds, over 150 images. But that's not all. They found out that he was hiding cameras going back over 6 years into rooms, hiding cameras, recording them, and then listen to this. He was digitally placing himself in the photos to make it look like he was doing it. A teacher. Now, what did they do when they went to sentence him, holding the royal flush, holding all the evidence? Well, Connecticut legislation allows for 20 years for having 150 images or more. Forget the voyeurism, forget the violation of protection order, which he did while he was locked up. Forget the creation of CP. Forget all of the charges that they could have charged him with. They could have gone him simply on the possession 20 years. But instead, they offer him a 10-year plea deal. But he doesn't want it. He says, I don't want the 10-year deal. What did they do? Did they say, okay, let's take it to trial? We can't lose this case. We don't even need to put victims on the stand. He had more than 150 images. That's 20 years. No. Instead, they said, oh, okay. Well, instead of 10 years, we'll give you 3.5 years or 42 months. He's a math teacher. He'll correct me. And that's the deal they agreed on. And here we are, halfway through that, up for parole. Just wait till you hear the excuses this former teacher and coach gives. Now with that, let's jump in.
Gregory Kelly, 446628.
Thank you. This hearing is being conducted in consideration for fraud conviction for Gregory Kelly, 446628. He is serving a sentence of 7 years execution suspended after 42 months with 30 years of probation for illegal possession of child second degree and 2 counts of voyeurism and violation of protective order. As of today, records reflect a eligibility date of July 4th, 2025. There is victim input in this case. There is an offender accountability plan for the offender. It has been reviewed and shows the offender has completed the following programs: Voices and Track 1. Utilizing the statewide collaborative offender risk evaluation system scores, the offender's overall score for recidivism falls in the low range. There is also a static 99 score over 3, which falls in the low to moderate range. This is your opportunity to express to the board why you believe you should be granted parole. You may begin.
Good morning. I'd like to thank the members of the board for taking the time to consider my application for parole. First and foremost, I would like to start by addressing the victims of my offense. I'm deeply sorry for all the pain and harm I have caused you. I'm sorry for the disrespect, shame, and blatant disregard for the trust you had placed in me. I accept full responsibility for my heinous actions and feel extremely shameful and remorseful for all the pain I have caused to my victims, my family and friends, and the community that placed their trust in me. I appreciate the opportunity to tell the members of the board how I have used my time while incarcerated to learn from my mistakes, better myself, help others, and ensure that I will never reoffend. During my time at Colorado Robinson Correctional, I have participated in the long-track sex treatment program and the Voices program. I work as a daily math tutor for inmates working to earn their GED, attend a graphic arts class every day, participate in daily Bible studies, and spend time reflecting on my mistakes and ways to ensure that I never repeat them in the future. I was able to accomplish all of this while also remaining disciplinary report free. While enrolled in these programs and classes, as well as my work as a tutor, I had great attendance and received excellent work and program performance reviews. Since the incident that led to my arrest, I have taken many steps to identify, understand, and fix what led to my actions. Now that I understand my medical issues and have received therapy and regular medication, as well as a relapse prevention plan that I created during my treatment program at Colorado Robinson, I'm very confident in my ability to rejoin society and avoid ever reoffending. I assure you that I will never reoffend. I don't want to reoffend, and I have the support in my life to ensure that I will never reoffend. If I'm granted parole, I will abide by any and all required stipulations. I plan to continue my work with helping adults continue their education as they work to earn their GED or take college classes. My goal is to regain the trust of others and become a positive member of society once again. It is extremely important that I once again become the role model that my two sons see me as, and that I show them that it is never too late to make the necessary changes to be able to do great things and be a great person. Thank you.
All right, Mr. Kelly, thank you for your statement. We do have some questions for you. When we're done, we'll turn to the Office of Victim Services for input. Then we'll deliberate and give you our decision here today. Okay?
Yep.
All right, so if I'm being honest, Mr. Kelly, I was a little concerned with some of your statements in your interview with the parole officer. So, in preparing for, we read all of your file, obviously multiple documents, but it appeared in your interview you had some difficulty taking responsibility. So I'm just going to ask you, why are you incarcerated?
Because I committed a heinous act. It is something.
Well, I need you to be a little more specific.
Yeah. I engaged in voyeurism. I filmed a girl who was staying at my house, and when she was spending the week at our house, and I had a baby camera in the room that recorded her, and I saved the video and saved screenshots of it. I also had other child pictures on my phone and my computer. I do take full responsibility.
Okay, you're missing a count. You're missing a count. So you explained the child pornography.
I'm sorry.
And
Yes. Also, staying at another victim's house, I had a camera that I put into her room when we were babysitting them, and I had that video also on my computer. Sorry, I didn't mean to miss that.
Yeah. Do you know what I mean? You've been through a lot of programming, and yes. From what I read, you were an active participant, so you were very involved in your treatment. Do you know what it means to minimize something? You're an educated man.
Yes, yes. I'm sorry. I'm not trying to minimize it. I'm having trouble with my words right now. I know what I did was horrible.
You know, I think you
treated
are. I
them-
think you do intend to minimize some of it. I think you do. And I can almost understand why it's difficult. I mean, you went through great lengths with these images. I mean, I read about how you altered them and you've pretty much photoshopped yourself into the images with these children. And you know, the videos were in those bedrooms, two separate homes were strategically placed so that you could tape minors when they're undressed. And that's the reality. I mean, there's no point sugarcoating it, and you should be able to openly speak about these things after going through treatment.
Yes, okay. So the part of the issue is these happened when I had severe concussions and I have a brain condition, and it's hard for me to talk about because I'm not in the same mindset that I was at that time. I'm extremely embarrassed by my actions. I'm disgusted by my actions. I truly am. And after receiving treatment, I look back at that time and I don't recognize the person that I was at that time. So there is an embarrassment and a disgust with my actions that make it difficult for me to really just discuss in detail.
So do you truly believe, and do you really attribute all of this behavior to concussions?
No, not completely. I clearly, it did have an impact for sure. I have no doubt about that, but there was definitely underlying issues that I had. I do not 100% blame those the medical issues.
Yeah.
But I do truly believe that they did play a part in exposing other issues that I was not aware of.
Well, were you also abusing medications at the time?
Yes, I was prescribed. Being prescribed alcohol, and when I stopped taking that, I found that was really messing with my brain chemistry, and that I'm not blaming that, but I do think that was also a factor in mixed with the other issues, my underlying issues plus the concussions and the brain condition with the medication. I do think the mix of all of that did have a combination effect. And when I stopped taking that, I did notice a dramatic difference.
Yeah.
And I was on a relatively high dose, and I was taking them in ways that I in more at a time than I should have been at times.
Right. Abusing, like I said. Yeah.
Yeah,
Were you
and
married
I
at the
did go
time?
I'm sorry, what was it?
Were you married at the time of these offenses?
Yes.
Yeah. Okay. Did you think to ask your wife for help? I mean,
I didn't. I wish I had. I found out the fact that when I did get help, it was a much better alternative.
Yeah.
And I do find that getting help works. I see mental health here, and just talking to them just about anything.
Yeah.
I find it helps. And I went to mental health treatment while I was after my arrest, but before incarceration. And I went to an in-treatment facility or inpatient facility and received outpatient help. And I found that those were very helpful. So it is something I learned after the fact. It was too late, but I do wish that I had talked about my issues at the time.
Yeah. Yeah.
I had a hard time talking about my inner feelings and things like that at the time.
Yeah. So you took the Voices program, and certainly I'm sure in the Track 1 program you discussed this too, but do you understand the impact you've had to, I mean,
Absolutely.
So many people, it's just a ripple effect.
Yes. Yeah. I mean, the obvious victims are the two girls that I completely intruded their trust and hurt them in countless ways, and it's something that I know that they're going to have to live with for the rest of their lives, and I feel awful about that. It affected my family. I have 2 sons that have to grow up with the effects of what I did.
Yeah.
I was a very active participant in their lives. I was an excellent father, and this took me away from them. They have to talk to me on the phone while I'm incarcerated, and I know that that's tough on them. They're without me, and I know they miss me. When I told them I was leaving them, the tears and just the hurt.
What about your community? All the people in the community, the schools, everybody then had to wonder. All the kids you taught, all those parents had to wonder if they were victims too. All the children and the images, the pornography images that you had, those being used for gratification. It's endless. The amount of victims that you have is endless.
Yes.
I'm happy to see that you have no disciplinary reports and that you are giving back and tutoring while you're incarcerated. I certainly hope that you'll find ways to continue to give back. I mean, your sentence does not go on forever, regardless of what we do here today. You have 30 years probation, which is a long time, but for good reason. I mean, you'll continue to have treatment that you very much need. I understand you're in the MAP program now.
Yes, I'm getting off of that at this time.
Okay, well, I mean, if it works for you, it works for you.
Yeah. I'm trying to get off that and not be on it anymore.
Yeah. Just so you know, the state's attorney's office did write in objecting to parole release for you. Understandably, yeah. Okay, and you did get good and excellent evaluations for your programming and work inside. So the facilitators certainly do recognize your hard work. Thank you for speaking with me. Mr. Zarko?
Thank you, Madam Chair. Good morning, Mr. Kelly.
Good morning.
After your arrest during the pre-trial period, you ended up violating the protective order. Can you explain why you made that choice?
Yes, I was in a extremely depressed state, and I posted something online. It was a suicidal ideology, and the sister of one of the victims saw my post and reported it. It was posted as a story, and she was one of the people who had access to see my story. And it was something I deeply regret. I should never have posted anything like that. But that was actually the start of me getting the mental health treatment that I needed. I don't want to say anything, it was a good thing in any way, but it at least got me pushed in the right direction to address my mental health issues. But I did not intend for the victim to be contacted at all, but it was definitely a mistake that I made to post anything out in the public like that the victim or their family could have seen. I did not think about it in that way at the time.
Whatever happens today, you'll be on probation for a long time, right? You'll be on the sex offender registry for 10 years. You'll have to do treatment in the community that comes with a polygraph exam and everything else that comes with that treatment. What do you think is going to be most difficult for you in the community?
I think living with the stigma of what I did and trying to prove that I can be a positive member of society and try and get the chances. Like I said, I do hope that I can get back into helping people, continue what I'm doing here with helping people attain their GED or college level classes, adults continuing their education. I don't know what my restrictions will be. That's dependent on I'm not quite sure. I need to research that, but I hope that I do have an opportunity to be able to do that. But I find that finding opportunities where I can help others in a way that I truly want to help others, I think that is going to be my biggest challenge, and something I hope that I'm able to get the opportunity to do.
Thank you. Thank you, Madam Chair.
Thank you. Mr. Comer?
I just have a couple of thoughts. So, Mr. Kelly, do you think, had you not been experiencing this neurological problem, that you would not have committed these offenses?
I wish I could answer that with certainty. I don't know. It was the combination of all the things I mentioned before. I would like to say no, but without having everything exposed to me and receiving the treatment that I received and just learning about what was going on with myself, I can't answer that with 100% certainty and say no, it never would have happened, or yes, it would have happened.
Part of participating in the offender treatment program is you talk about triggers. And you mentioned that you will avoid your triggers. What triggers did you identify?
Well, for one, using any kind of medications that may affect my cognitive awareness. I definitely won't be using that I used or anything along the lines of that. I'm going to avoid any situations where I have any opportunity to be around girls in case that is a trigger. I have no intention of putting myself in any situations where anything may happen, or I may have thoughts that I don't have outside of that situation. And also, I'm going to be more open with family if I do have head issues. If I do receive another concussion, I am very susceptible to them with the neurological condition, QR malformation I have. If I do have any issues like that, I'm going to immediately talk to my parents, my brothers, or anyone else in my support system at any given time and let them know what's going on and ask them to help me through it and make sure that I'm not doing anything out of the ordinary, acting in ways outside of my normal ways of acting, so that they can look for anything that may be out of the ordinary that would be signs that something is going on. I've been very open with my support system about what to look for and just to monitor me closely to make sure that I'm not acting any differently.
Right. And you've thought about what parameters you need to put around yourself in terms of a relapse plan.
And I didn't understand that question.
So at the end of treatment, you develop what they call a relapse prevention plan. So you've identified triggers and figured out, how you'll live within the parameters.
Yes. And that's mostly with the support system that I have in place.
You completed treatment in November 2024. So what have you been doing since then to prepare for being in the community?
Well, I've been doing the tutoring. I've been working on, I entered the graphic arts class just to work on like my artistic abilities. I talk to my family. I attend church and Bible studies in the dorm, and I talk to my sons, my family, and kind of talk about the plans that I hopefully have when I get out. And one of those plans is the tutoring for, continuing the tutoring and helping adults with continuing education. That's a big part of my plan. And I think if I'm on that path with the assistance of my family, I will have the support to kind of avoid any situations where I could potentially relapse.
You know, I couldn't help but wonder as I was reviewing the material for your case today that you reported having a number of concussions and it affects you cognitively. Yet you continue to teach, you tutor. It doesn't affect your ability to participate in those kinds of activities?
The tutoring I do here is for about an hour and a half. And as long as I keep it in short amounts of time, I'm okay. I start to get really bad headaches and dizziness if I'm exerting for too long. And one of the big things is memory loss. I have a lot of gaps in my long-term memory and my short-term memory with names and stuff like that. But the reason why I think I'm okay with the tutoring with math is it's more about problem solving and figuring out and not as much about memory. So that's just always how I've approached it. So I'm able to help out with the math stuff because I still have the ability to do the problem solving. It's more of memory-based issues.
Okay, but how about when you were teaching? It didn't affect you at all to teach daily, hours at a time?
The end of my teaching career, the last year I actually taught, I had to take off the end of the school year because of concussion related issues. And I missed time at various points because of those concussion related issues. But overall, it wasn't as bad early on in my teaching, and it was getting worse and worse as time went on.
So in 2019, when these offenses occurred, it was not affecting your ability to teach, or it was?
It was at the end of the previous school year. I missed a significant amount of time because of it, which I think would have been April, May, June, that time frame of 2019.
Okay, thank you, Mr. Kelly.
Thank you. Okay,
Thank
Ms.
you.
Kelly, at this point, we'll ask the Office of Victim Services to provide input. You can listen, just please don't interrupt. Ms. Hamlet-Williams, thank you.
Thank you, Madam Chair. I do have a statement from the victim in this case, and it reads, I am writing today not as the 16-year-old girl whose life was shattered by these crimes, but as the woman I've been forced to become because of them. My statement was about the crime itself and the devastating impact it had on me and my family. My first statement was about the crime itself and the devastating impact it had on me and my family. This statement is about the future and why early release should not be granted. The truth is simple. This individual is a danger to children. These crimes were not accidents, mistakes, lapse in judgment, or the result of getting too many concussions playing high school football. They were deliberate, calculated, and carried out over time. Trust, authority, and access to children was abused. These actions were planned, concealed, and only admitted to after being caught. That reveals the core truth. This is someone who cannot ever be trusted around children. The emotional damage I suffered has not gone away. It lingers even years later. I am still rebuilding my ability to trust, to feel safe, to believe that people are who they appear to be. I live with the knowledge that at 16, my body and privacy was stolen and turned into something for others to consume. That violation cannot be undone. To this day, I feel the impact in ways big and small. And the thought of early release reopens that fear all over again. A full sentence was given because these crimes are among the most serious and vile imaginable. To even consider cutting that sentence short would be to spit in the face of every victim of child exploitation. It would tell me and every child who has suffered like me that our pain is negotiable, that the permanent destruction of innocence can somehow be repaid with less than full justice. Granting early release would not only dismiss the weight of what was done, it would brand this board complicit in excusing a predator, and it would put more children at risk of living the same nightmare I still live every day. Early release would not only endanger the community, it would re-traumatize me and my family. We trusted the justice system to protect us and to hold this person accountable. If that trust is broken by releasing him early, the harm to me will be compounded. Serving the full sentence is the bare minimum of justice. A choice was made to destroy my childhood innocence and betray my family's trust. A choice was made to lose a position of authority. A choice was made to repeatedly download. A choice was made to plant a hidden camera in my bedroom and record me after the shower. Those were intentional acts of predation that carry lifelong consequences for me. They must carry the full consequence in sentencing as well. Those choices carry lifelong consequences for me. They must also carry the full consequence in sentencing. Good behavior in prison is not an accomplishment. It is the minimum expectation. It does not lessen the severity of the crimes committed, nor justify an early release. I am asking you with everything in me to deny early release. Anything less would endanger children and betray justice itself. Thank you. Thank you, panel.
Thank you very much. Okay, Mr. Kelly, give us a few minutes to discuss your case and we'll come back to you shortly with our decision.
Thank you.
It's well put by the victim, I would say, and I tend to agree with a lot of the points made. It is difficult for me to accept that this was because of any kind of medical condition, because he was functioning very well in other areas of life. He says himself, he was a great dad. He was a teacher. He was a husband. So as I mentioned before, I do find him to be minimizing a bit, and for whatever reason, he betrayed the trust of a lot of people, affected a lot of people. And I don't want to take away from all the work that he's done. He's done some great work with programming and tutoring, giving back in the community. But given the short sentence, the greater impact on all of the victims involved, and he does have a probation term to follow, I would not vote to grant parole today. Mr. Sarka.
I think the nature of this offense itself is frankly disturbing.
Yeah.
Especially given Mr. Kelly's trusted role in the community as an educator. I do agree that he tends to minimize what actually happened, and I will not be supportive of his discretionary parole today.
Thank you. Ms. Smith-Plummer?
I would also not be in support of discretionary parole today. The offense outside his own home, to me, it's premeditated.
Right.
He planned it, he focused in on what he needs to do. I agree that it's definitely minimizing in terms of when all that was occurring and how he sees it now.
Yeah.
Seeing it as a medical issue, I don't think allows him to really appreciate the gravity of it.
Mm-hmm.
And also, Mr. Kelly is a 4 in terms of his addiction. I think the MAP program is one aspect of helping him with that. Perhaps the rest of his time can be used to take an addiction servicing program to enlighten him also of how that plays into behaviors and can begin to store through things.
Yeah. Okay. Thank you. All right. In the matter of Gregory Kelly, inmate number 446628, I'll move to deny parole for the following reasons: the nature and circumstance of your offenses, the injury and impact to your victims and their families. Is there anything you want to add? Anything further?
No, I'm sorry.
Nature and circumstance and the injury and impact to victims.
Yeah, nothing.
Okay. Is there a second?
Second.
All in favor?
Aye.
Aye. We wish you the best of luck, and we certainly hope you'll continue to work on yourself. Thank you.
Can I ask you a question real quick?
Sure.
Is this a full denial or a?
It is. Yeah.
Okay.
Yep. Thank you.
Thank you.
Hearing for Gregory Kelly 446628.
They denied, and it's not an automatic because, you know what, on this day's docket, the parole board saw about 5 other chomos, and they paroled most of them, even with the victims pleading for them not to get paroled. But I'm going to focus, instead of the parole board, they did their job this time. I am going to focus on the insanity, the agenda-driven, perverted, sick judges and district attorneys in the state of Connecticut. Do you want to know why? Because the state of Connecticut, they had the royal flush. Legislation would allow them to sentence him to 20 years in prison. 20 years simply for the possession of 50 or more images. A minimum of 5 years. Still more time than the sentence they gave him today. How many images did they actually find him with? 150. 150. Now, it wasn't only 150 that they found him with, but they found the victim who you heard, the cameras that were hidden in her room. That was done years ago when she was 16. It was only years later that they found those videos. He then put images of himself and created CP of it. Do you know how many years you can get in prison for creating CP? See, my point is that without putting anybody on the stand, without using the typical excuses that they use for why they don't, want to sentence these people, they could have gotten him simply for the CP possession. Do you know that he was a teacher in middle school? That he was also a coach for their sports teams? This is a chomo that has been playing on little ones for as long as we know. And they give him a deal? Let me read to you these articles, and this is just the tip of the iceberg. Do you know that the schools didn't even notify any of the parents about this? They didn't notify the parents that a teacher was arrested for these acts? That became a talking point, but there's only so much we can focus on. Let's just go through this right now. Former Stanford teacher, and they call him Stanford teacher instead of like elementary or middle school teacher. They want to make it look like maybe he's a college teacher, right? I guess they didn't say professor. Former math teacher, isn't it funny? He's like, oh, the math, it's simple, it's problem solving. Yeah, it's like he's trying to like gaslight us. It was from football, CTE, F you. And they're still giving this guy deal, someone who's blaming it on football. And I'm still my brain. It's yeah, I don't know. I was doing it because of my ADD medication. Oh. These judges, they're agenda driven. They're sick. There's something wrong. They don't want us to know about this. These parole that they're giving out these sentences. Let's just look. Let me walk this through, okay? Former math teacher Gregory Kelly used his Clunan middle school account. He's using that's how smart. Maybe he does have CT. He's using a school account to do it. Images of but someone who does that is someone who's very comfortable, who's been doing it for so long that they become confident, they become cocky, they become careless. To upload images of alleged CP According to his arrest warrant, the recently unsealed warrant also details Kelly allegedly secretly filmed 2 teenage women, although they call them women, they're 16 years old, these sick people. He was tasked with watching while their parents were away, and he was watching them with his wife, by the way. So for those who say, "Oh my God, how could you put him in?" He's watching them with his wife. It was his wife's friend. Kelly, who pled not guilty at his arraignment Thursday to felony charges of possession of CP and voyeurism, was arrested February 7th following a 6-month investigation after the National Center of Missing Exploited Children warned Stanford on August 1st that someone was uploading images of CP for a Stanford school account. Do you even imagine it took him 6 months to get an arrest after knowing it's someone from a school address? Kelly, the father of 2 young children and a former coach, was living in Stanford at the time of his arrest. He has since moved to New Jersey after posting $500,000 bond. Kelly's attorney declined to address specific activities that his client was alleged to have undertaken the warrant, but said there could be some legal issues raised that may help Kelly. Okay. In cases of this nature, there are usually issues surrounding search warrants. Okay, obviously they don't work for him. Police said Kelly turned himself in when he learned that a warrant had been granted for his arrest. School district officials say he has since resigned and is no longer employed at the district. Kelly was put on leave by the school once officials were notified of the investigation into his alleged allegations. The warrant, unsealed Friday afternoon, says 8 CP files were uploaded July 30th after the tip. Stanford police quickly determined the IP address used to upload the files belonged to Stanford Police District. They traced the latitude and longitude information to the middle school. The documents uploaded contained personal and work information, who at the time was employed as a school math teacher. There were images. The images were enough for police to get a judge to sign a warrant. The raid took place at 6 a.m. That must have been a nice surprise. His wife, "Why are there police here, honey?" "Police and that's my concussion. It must be that's why." During the search, officers seized more than 24 items that were taken to be analyzed. The affidavit later said that day that officers went to Kelly's classroom, room 303, and inside a locked closet they found and seized a laptop, flash drive, 2 computer towers, a monitor, 3 additional desktop computers, all of which Kelly had used. After searching the devices with help of the FBI New Haven Forensic Division, scores of CP were discovered. While there is no indication that Kelly knew of any children depicted in the images, police were able to identify victims in 2 videos filmed using hidden cameras. According to the affidavit, one woman showed a young woman in her bedroom. Using the images from the video, police were able to match them to the Instagram account of a woman that Stanford discovered she was friends with on Facebook with Kelly's wife. When police spoke with the new college-age woman, she gasped and told them she recognized the room as a spare room in Kelly's home. The affidavit said that she had likely been filmed in 2016 when she was 16 and staying with Kelly's family for a weekend while her parents were away. The woman said Kelly's wife was her math tutor and a good family friend. When asked if Kelly ever did or said anything inappropriate to her, she said he was a bit weird and nerdy, but nothing beyond that. The second video showed Kelly set up a camera in another bedroom and then leave. A few minutes later, a different young woman entered, an undressed young woman, also 16. For the second victim, police did not say how they identified her, but they showed her the video. She immediately began crying and told investigators it was filmed in her own bedroom. Her own bedroom. When asked who would have access to the room, she blurted out, "Greg Kelly." She knew immediately who. The woman told police around 2014. So this was they know that he was doing this for 6 years up until that point. While he's teaching. How do you not throw the book at him? Because there's just something wrong. And again, they had the royal flush. And look what happened, by the way. They let him negotiate out of a harsher term. Kelly and his wife would stay at her house with their parents were away and babysit her and her brothers. When she asked if Kelly had acted appropriately to her, she once remarked on the mobile messaging app Snapchat. So he once sent her, a 16-year-old, that you look very grown up. The woman said she thought the comment was creepy and blocked him out after that. And again, she was 16 at the time. Police said Kelly took still images from both the videos and digitally altered them to make it appear as if he was doing it with them. At his arraignment Thursday, there's the two-faced judge. Judge Bruce Hoddock issued 2 protective orders prohibiting Kelly from contacting or stalking both the women. Kelly is charged with 5 counts of second-degree possession of CP, 2 counts of third-degree CP, and 2 counts of voyeurism. Now, why is he only charged with 2 counts and not 150 counts? We'll never understand this. I know the PhDs need to explain it to us, right? The DAs, the judges, they need to explain it to us. Now, there was another article that talks about here. Let me share. There's so many ads on this one. I just hate it, but let me share it with you. There's enough meaningful information in here. Look at can you even imagine this headline? Teacher gets arrested. Should schools inform their communities? This is what they're asking. Can you even imagine that? Should schools inform the communities? It should be by law that they inform the parents of the teacher. It's insane. He was a teacher on administrative leave employed by the school of Stanford. He was arrested last week for CP and voyeurism charges. He was not a current employee at Greenwich School, but had recently worked there as a district coach. I don't even know what this means. So they're talking about different schools. He was a coach in one and a teacher in another. While Stanford parents received a letter about the arrest, Greenwich parents did not. Oh, so it's 2 different school districts. He was a coach in one and a teacher in another. He just couldn't get enough of his prey. He just couldn't get enough. Following Kelly's arrest Friday, police said he was found in possession. Can you imagine being a coach for little ones and having this? Like, it's so insane. I know I sound whiny, but I can't help it. What can I do? You don't believe what you're seeing. Video of 2 teenage female victims. David Tate, principal of Stanford College Middle School, sent a letter home to her parents alerting them of the situation. I urge you to take this opportunity to open and continue conversation. Oh, shut up. Kelly teacher could have been administrative leave. More ads pop around. Let me not scroll. It's great user experience. You're doing a great job, all of you local pathetic papers. At least they covered the story, right? He was a former coach at Greenwich High School freshman basketball. He was a high school freshman, just the age he likes, right? Basketball team at Eastern Middle School basketball and soccer teams. Employees recently as 2019. Public schools, he did not release a formal letter to the parents. They did not release a letter to the parents or staff. That's great. That's great. You have one job as a school, and they wouldn't even do that. He's not a current employee. Spokesperson said, we do not have any additional information beyond that he was shared in general public. Shut up. Like, how could you, why? Because you don't want to deal with the headache of parents freaking out. Sorry, it's not only your job, it's your fiduciary responsibility. You should want to do it. You should care about your students. So what? There's going to be headache. He worked there. You do need to, it's the right thing to, it's the only thing you can do. There are no state laws that require school districts to notify community members of teachers arrested. Well, wouldn't that be easy legislation to pass? Wouldn't that be? But it's best practices. You just can't make this stuff up. You really can't. You really can't. I thought that it was appropriate. She said, I don't know that's a mandate, but responsible human beings, yes, that's what you would do. No kidding. It seems a natural reaction to say if anyone from your community is affected. I can't read these things with these articles. Where's the other? There's an article. I need to now find it for you, but it said that it talks about the plea deal, and here it is. On Thursday, Judge Gary White sentenced Gregory Kelly to 7 years in prison, but it would be the execution of which will be suspended after he serves 42 months. He will also have to serve 30 years probation according to the court documents. So that was the plea deal they agreed to. Remember, they could have gotten him for 20 years just on the CP. Now, in December of 2022, this is what I was looking for. He rejected an offer which he would have received a 20-year prison sentence, suspended after he served 10, and 20 years probation. So now that we know that they knew that they could give him 20 years just for the images, and they gave him a 10-year deal, he rejected it. And what do? Do they take it to trial? Do they say, okay, you turn this down, we'll give you even more? No. Instead, they say, oh no, the teacher who's a chomo, who's been doing this for years, where we have the royal flush, we cannot lose this case. No jury will find him innocent. We don't even need to put victims on the stand. We can charge him just for the CP. Forget the voyeurism. What do? They say, oh, okay, you're right. You're right. We'll give you 42 months instead, which is 3.5 years if I'm doing my math correctly. I don't know. I am learning disabled, but maybe he can help tutor me on the math over there. I really like, again, it's these agenda-driven judges and district attorneys, and I say that now, but before I used to, it's my new word, agenda-driven, because it has to be an agenda. There has to be something where maybe they're chomos as well. Maybe they, I don't know what it is, but you're a teacher, you're a coach, and the victims are the age of the people who you teach. You have the royal flush in the images. Even the charges that they invest a 6-month investigation with the FBI. Think about just the cost of that. I wonder what the sticker cost is on the, and then you can lock him away. You have legislation to lock him away probably for his whole life. Certainly for 20 years just on the CP if you didn't want to put the actual real life victims on the stand. Don't charge them for the voyeurism. But it would have been CP. It would have been manufacturing CP. I mean, you could probably think of endless just the law nerds here. Forget what those with the actual degrees. It would have been, you could have had a field day writing him up with charges. But it's probably what happened is the DA is like, no, I don't want to charge him with that. No, I don't want to. I don't feel comfortable charging with that. No, I don't want to. Let's just charge him for possession of this and this. Why? And then what's going to happen? No matter what, he is getting out March 23rd of 2027. That's it. That's it. You really can't make it up. Oh, and then the insult to injury. His static 9.9 is a low to moderate range. How? There's such clowns. I really, I can't. I get exhausted with this. I do. This is we need, like, there's just someone needs to, I need to sit across from a judge and say, explain this to me like I am his victim. Why? I'm here, I'm waiting. They can't. They can't. And yeah, this is why we do this. This is why. And with that, I'll let you go.
This is someone who cannot ever be trusted around children. The emotional damage I suffered has not gone away. It lingers even years later. I am still rebuilding my ability to trust, to feel safe, to believe that people are who they appear to be. I lived with the knowledge that my body and privacy was stolen and turned into something for others to consume. That violation cannot be undone. To this day, I feel the impact in ways big and small, and the thought of early release reopens that fear all over again.
I want to be better because I realized my mistake. But how could you realize your mistake if you say you didn't make a mistake? How can you say I'm better when you didn't do anything? Better from what? Where's his starting point where he's saying, hey, I did I was around the wrong people and now I'm better? But you didn't plead guilty and you're not in jail for being around the wrong people. But by the letter of the law, that's all we're talking about. You pleaded guilty to strangling another human being. And he takes no accountability for that, ma'am. I'm sorry, members of the parole. He takes no accountability for it. You heard him. I can listen to him the whole thing. And I think that's a problem. And I'm not saying he's going to go out and do this again to someone else. I'm not even worried about that because that's not going to bring my daughter back. Nothing's going to bring my daughter back.